Hello and welcome. In this video, we'll be dissecting a critical topic in civil procedure: venue of actions. By the end of this session, you will be able to distinguish between real and personal actions for venue purposes, identify the proper venue for both residents and non-residents, and analyze the validity of venue stipulations. You might be wondering, what's the difference between venue and jurisdiction? This is a common and crucial distinction to make, especially for the bar exam. Jurisdiction is the court's power to hear a case. It is conferred by law, cannot be waived, and in civil cases is the court's subject matter jurisdiction. Venue, on the other hand, refers to the place where a case is to be heard. It is a procedural matter designed for convenience, and importantly, it can be waived. Think of it this way: a court's jurisdiction determines if it has the authority to listen to your case at all. Its venue determines which specific courtroom your case will be heard in. Our first topic is Rule 4, Section 1, Venue of Real Actions. The general rule is that actions affecting Title II, possession of, or interest in real property must be commenced and tried in the proper court where the property or a portion of it is situated. Let's break this down. Real actions involve land. If the case is about the ownership of a house, a piece of land, or the right to occupy it, you must file it in the court located in the same geographic area as the property. This rule, that an action must be filed where the property is located, is called a local rule. The court where the land lies is the only one competent to adjudicate it. Remember the acrostic, PRI, which stands for property's location is required. The syllabus notes that ejectment cases, which include forcible entry and unlawful detainer actions, are a key example. These are real actions. Forcible entry is when someone takes possession of land or building by force, intimidation, threat, strategy, or stealth. Unlawful detainer is when someone lawfully obtains possession, but their right to possess the property has expired or been terminated, and they refuse to leave. These are special summary proceedings heard by the municipal trial courts. So, a case for forcible entry into a building in Makati must be filed in the municipal trial court of Makati. It cannot be filed in Taguig City, even if both parties live there. The location of the property is controlling. Now let's shift our focus to Rule 4, Section 2, Venue of Personal Actions. Personal actions are the all other actions that don't involve real property. The rule here is much more flexible. The plaintiff has the election or choice. A personal action may be commenced and tried in one of two places at the election of the plaintiff, either where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides. So, the plaintiff has the power to choose. They can sue in their own home court, or they can sue in the defendant's home court. For example, if a resident of Quezon City sues a resident of Manila over a personal debt, the plaintiff can choose to file the case in the courts of Quezon City or Manila. The bar trap to watch out for here is the difference in language. For the defendant, the venue is where they reside. For a non-resident defendant who is found in the Philippines, the venue is where they may be found. The key is that the plaintiff makes the choice. Let's work through an example. Scenario: Paul, a resident of Cebu City, owes Dexter, a resident of Davao City, 100,000 pesos. Dexter files a complaint against Paul to collect the debt. This is a personal action for a sum of money. The plaintiff is Dexter, who resides in Davao. The defendant is Paul, who resides in Cebu. Dexter has the election. He can file the case in the courts of Davao City or in the courts of Cebu City. If he files it in Taguig City, where the debt was incurred, it would be a wrong venue, and the case could be dismissed. What if one of the parties is not a resident and is not found in the Philippines? This brings us to Rule 4, Section 3, Actions Against Non-Residents. This section applies when a defendant does not reside and is not found in the Philippines. The rules change because it's impossible to serve process on them in the traditional way. Here, venue depends on the nature of the action. We can break it down into two types of actions. First, if the action affects the personal status of the plaintiff, the case must be filed in the court of the place where the plaintiff resides. An example of this is a petition for declaration of nullity of marriage. The plaintiff's residence dictates the venue. Second, if the action affects any property of the defendant located in the Philippines, the case must be filed in the court where the property or a portion of it is situated or found. An example is an action to recover a debt by attaching the Philippine-located assets of a foreign defendant. This distinction is critical for the bar. Bar tip. For non-residents, think about the subject matter of the case. If it's about the plaintiff's status, it's their residence. If it's about the defendant's property, it's the property's location. Let's consider a scenario. Scenario. Anna, a resident of Makati, files a case for declaration of nullity of her marriage. Her husband, who is from Germany, has never resided in the Philippines and is not found here. This action affects the personal status of Anna, the plaintiff. Following the rule, the venue is where Anna resides. Therefore, the case must be filed in the Regional Trial Court of Makati City. The husband's non-residence doesn't affect this venue rule. What if parties agree on a venue? This is covered by Rule 4, Section 4, when rule not applicable. This rule outlines two exceptions to the general venue rules we've discussed. The most important for us is the second one, a valid written agreement between the parties. The parties in a contract can stipulate or agree that any lawsuit arising from their contract will be filed in a specific venue. But for this stipulation to be valid and binding, it must meet three conditions. First, the agreement must be in writing. This is crucial for proof. Second, it must be made before the filing of the action, usually as part of the original contract. You can't just agree on a venue once a lawsuit has already started. Third, the stipulation must be exclusive. The contract must clearly state that the designated venue is the only venue, typically using words like exclusive, sole, or only. A common bar trap involves a contract that is not exclusive. If a contract says, venue shall be in Quezon City, without using exclusive language, it is merely an additional venue, not the only one. The plaintiff can still choose their or the defendant's residence. The stipulation is only binding if it is clearly exclusive. Another bar trap is that the stipulation only binds the parties to the contract. It cannot bind third persons who are not parties to the agreement. We've covered when venue is a matter of procedure. Now for the very important part, when venue is jurisdictional. Generally, venue is procedural, meaning a party must object to it or risk waiving it. However, in certain cases, venue is jurisdictional, meaning the court's very power to hear the case depends on the correct venue. Failure to follow these rules is a jurisdictional defect that cannot be waived. The primary example of jurisdictional venue is criminal cases. Under the Constitution, the venue of a criminal action is the place where the offense was committed. If a crime is committed in Quezon City, the case must be filed and tried there. It cannot be waived. Beyond criminal cases, there are other instances where venue is treated as jurisdictional, not procedural. These include ejectment cases, which we discussed earlier. The case must be filed where the property is located. Also, actions in rem or quasi in rem. These are cases where the lawsuit is about property itself, not just the people involved. These actions must also be filed where the property is located to be valid. The key bar line to remember is this. In civil cases, venue is procedural. It can be waived. But in criminal cases, venue is jurisdictional. It cannot be waived. This is a common test question. To recap, we've learned the distinction between venue and jurisdiction, defined real and personal actions, and identified their proper venues. We also analyzed valid venue stipulations and, crucially, understood when venue becomes a jurisdictional matter. Master these distinctions and you'll be well on your way to success.